So this video describes what collation means in context with Louisiana estate planning law. Paul Rabelais here. I'm an estate planning attorney here in Louisiana, helping people all over the state get their legal affairs in order and then making sure things get settled the right way when they pass away. This is one of those things where, boy, we get questions about it all the time, but it's largely irrelevant. It's not uncommon for there to be a provision in a will that says something about collation. And collation is a Louisiana collation. And, you know, what is collation? And quite frankly, it's one of those things that's in wills that causes people to say, what does that mean? So let's take a look at it and just get it out of the way so that you can move on with perhaps more important things. So in the old days, and I'm going to define the old days as the pre-1990s, there was this presumption in our Louisiana law that said parents were supposed to treat their children from an inheritance standpoint equally. And so if a parent, before they died, for example, gave child number one $50,000, and we're disregarding gift and estate tax laws right now, and they didn't make that same gift to child number two and child number three, then when parent died, child number two and child number three could come back in and say, well, wait a second here. My sibling, child number one, got $50,000 before my parents died. That's counted as an advance on their inheritance, so child one gets less. Now, so that was the case in the old days, and even in the old days, the parents in their will, and typically did have a provision in their will that said something like, I exempt my lifetime gifts from collation. So that meant when parent died, they didn't have to go back and account for gifts that were made to children. Three children would typically just split whatever was there when parent died. Now these days, they've really, in the legislature, watered down the collation provisions, primarily because of a change to our forced heirship laws that took place back in the 90s. So now, here it is this collation. It only applies, and the only people who can demand this collation or this kind of fictitious return of gifts are children who are forced heirs when you die, and it only applies to gifts that were made within 3 years prior to your death. So looked at the other way, if your children are 24 or older, and then, you know, collations just can't ever be an issue unless you have children who are forced heirs because they're incapacitated. So I guess the way you look at it is, when could this apply? This could apply if, when you die, you have children who are 23 or younger, or you have children who are incapacitated at the time of your death, and within 3 years prior to your death, you had made some significant gifts to children who are not forced heirs. However, in your will, even that would not be an issue if in your will you said something like, I exempt my lifetime gifts from collation. So that collation provision has just hung around in wills for decades. It doesn't hurt anything. It just causes confusion and causes you to ask your attorney, what does that mean? So now you know. So it, like I said, it doesn't hurt to have it in there. Keep it in there. You know, you could take it out, you could leave it in, do whatever you want. But really, don't get too hung up on that. I'd get past that and start focusing on the more important estate planning aspects of, you know, keeping what you have, protecting it, making it easy for your children, avoiding lots of the other government intrusions, whatever it is that you want to avoid, whether it's the taxes or the probate or the nursing home expenses or the blended family issues and all those other things that we have to deal with on a day-to-day basis. So, but that's the deal with collation. Now you understand it. Move on to the next issue. Go take care of this stuff for your family. You'll be giving them a gift that they'll never forget. Have a great day.